Your client's interest right up until the moment that the trial begins, and even for some time after that, is to try and find a solution to their problem. Most insurers don't want to try a case unless they have to. Not all. That's not true for all. Most clients don't want to go to trial unless they have to. And again, there are some clients who want their day in court, so there are a few exceptions to the rule. But the vast majority of our clients want us to solve a problem for them. And by being disagreeable, by taking advantage of slip-ups, by bringing unnecessary motions, by failing to agree to reasonable requests for adjournments or for extensions of timelines, what you're doing is creating problems for your client, adding more money to the cost of the litigation, adding more delay, and that is not what's in your client's interest. Your client's interest is what's paramount, not your own interest as a lawyer. And the duty is not just to, and this is important for all of you to know out there as witnesses, my duty under the rules of professional conduct to be civil, to be courteous, is not just to the other lawyers, and it's not just to a judge or an arbitrator. It's also to witnesses. And so even on the stand, I have an obligation to live up to a certain level of professionalism in the way that I deal with you as a witness. And if I don't, I wouldn't ever, if Eric doesn't, then you should call him on it. I don't think there's anything wrong with that. Again, you've got to be very careful of being seen to be an advocate. But as a witness, you've always got to be above the fray. You are the professional. You are the expert. The jury needs to see you as the professional, the expert. And smacking down some lawyer who is being completely rude in a professional way, I think may be called for. And again, you should point out the rules of professional conduct to them. The judge will probably have a little chuckle, too, on the stand.
One of the things I learned early on in my career was that, especially if you're in front of a jury, you have to give the witness such latitude to be disliked on their own terms before you can try to smack them. Because the jury is rallying behind the witness. They can see themselves being put in that position a lot more readily than they can the position of the lawyer. And so their sympathies lie with the witness who's being cross-examined. And until and unless you get pleading eyes from the jury saying, could you please do something about this idiot that I'm listening to? Could you please upbraid them for what they're telling you? Because I'm not believing a word of it, and you're just letting them prattle on. Until you get that permission, you can't even come close to smacking them. You've got to be super, super nice. And so the problem that most lawyers face is they've been living with the file, they know what this witness is going to say, and they want to smack them the second they open their mouths. And they can't. It's really bad advocacy to do that at the start, because you then turn your jury against you because they don't understand why you're so angry. You've got to give them the understanding of why you're so angry and get them angry before you do it.
Yeah, and I think you're absolutely right that what a lot of lawyers miss is that interaction with the finder of fact, arbitrator, judge, jury. Because you've spent a couple of years, you've spent hours and hours writing your questions. They must be good questions. Damn it, I have to get them all out. And that, again, is just, it's simply poor advocacy. What you want to do is take your cue from the finder of fact. If the arbitrator starts to fidget, starts to check their BlackBerry in the middle of your cross-examination, you know that something is going wrong, and perhaps you should move on to another point and not ask the other 26 questions that you had under that topic, especially when they suggest to you, which has happened, once, Mr. Wagman, you might want to move on now.
And I had the obverse. I was doing closing submissions, and the plaintiff sitting at the next table pulled out this elaborate, it looked like a nativity scene. and she started doing all kinds of crazy stuff with baby Jesus and And this was all while I'm doing closing arguments. And she's gesticulating wildly, and I'm looking at the arbitrator, and I'm looking at this crazy lady, and the arbitrator looked at me, and I pretty well understood what he was looking at me with, what those plaintive eyes were saying, and that was, Grossman, if you actually stop and make me address what this lady is doing, I will kill you. So I carried on. Dealing with the arbitrator and the judge is another significant.
Let's talk about that, and then we should probably wrap up so that people can have coffee later than suggested. I know you had an interesting experience recently, so why don't we talk about good form in front of an arbitrator and a judge, and what to do when you've got an arbitrator or judge that you think hates your case and is going against you at every step of the way.
I don't want to talk about it.
This is where I get to sit back and have that.
I won't talk about any specific cases. I will simply say that when you're in front of somebody who you know isn't on your side as the decision maker, you have to be respectful for the process. Even if you have no respect for the decision maker, you have to pretend, and more importantly, make the record reflect that you do. And you have to have a keen eye on the record, and the record is the transcript of what's being said and what's being put into evidence, because thankfully in this system of ours, there is always someone above the initial decision maker who has an opportunity to look at that to see if that decision maker made a mistake or did something wrong. If you are being railroaded in your view, or if you are being taken to task for things that you shouldn't, in your view, be taken to task for, or having done something wrong that you don't think you did anything wrong on, you have to stand your ground. You have to be respectful about it, but you have to stand your ground, and you have to protect the record so that on appeal, the record reflects what has happened. And most smart decision makers are very keen about the record and will be extremely cognizant of what that record reflects. So they will say what they need to say to protect the record, and they will write in their decision what they think will need to be said to protect that record. And you have to say what you need to say to give you a chance on appeal. So an example of that would be, with respect, Mr. Arbitrator, I disagree with what you're saying, and my concern is that you will do the following with that. And so if you know where he's going, in most cases you do, you put on the record what you think he's going to do, and he will either ignore it or will say, well, you have no evidence that I'm going to do that. And then when he does it later, well, there you have the record. And so it's important to object to things that you find objectionable. It's important to, God knows in a jury matter, if you don't object to the charge, even if you think the charge is the best charge you've ever heard, if you don't object to the charge, you don't have any chance for appeal on the basis that the charge was improper. Because if the jury comes back and says, I'm finding for the other side and I'm going to do X, Y, and Z, then on appeal you're going to say, well, clearly the judge misdirected them. Well, if the judge misdirected them, where were you in terms of objecting? Problem, of course, is figuring out what those objections should be.
Well, and doing it quickly and respectfully. I mean, and standing your ground, I think, is the key issue there. And it happens a lot with young advocates where, you're afraid that you're pissing off the judge, or you don't want to piss off the judge. You've objected 3 times. The judge is now scowling at you. You got senior counsel beside you who's, rolling their eyes, pretending that they think you're an idiot. If they roll your eyes, it means you're actually getting somewhere, by the way. And so you don't tell them all the secrets. So you stop objecting. You stop getting on your feet. You're worried that you're upsetting someone or that you're embarrassing yourself. There's a reason that you're in court. You probably know what you're doing. You might have something to learn. We all do. But your instincts are probably pretty good. Keep objecting. Keep the record clear. You don't know if it's going to be the first objection or the 20th objection that might be your reasonable grounds for appeal later on. But if you never get to your 20th objection because you become, so scared that you're upsetting the process on your third objection, then you're not going to have an appeal that can be heard in the first place. You've got a duty to your client, stand your ground, doesn't matter whether the judge is trying to bully you, which happens, other counsel are trying to bully you, which happens a lot. Stand your ground, say your piece.
And there's a really interesting social dynamic with the jury that if you're objecting constantly and getting upbraided by the judge for doing it, all of a sudden the jury may rally behind you. Oh, who's this, this poor kid's getting beat up. I want to help him.
It's amazing how these decisions get made. We've probably gone way over time.